especially those who work in the service of others, police, medical personnel, and members of the civil service. We give special thanks today for our teachers during this first week of the new academic year. May all that is done this day be for your greater honor and glory through Jesus Christ in prayer. So may our Lord Jesus Christ be near us to defend us, within us to refresh us, around us to preserve us, before us to guide us, above us to bless us, who lives and reigns with the Father and the Holy Spirit, one God, forever and ever. Amen. Say the Lord's Prayer. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come. Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, power, and glory, forever and ever. Amen.
House is now in session. Minutes of the meeting held on Tuesday, the 28th of August, 2018.
Mr. Deputy Speaker, I beg to move that the minutes of the proceedings of the Honourable House of Assembly at its meeting of Tuesday, the 28th of August, 2018, which have been circulated, be taken as read.
I'd like to second that, sir.
Question is that those minutes become, if there's no errors or omission, please those minutes be confirmed.
Mr. Deputy Speaker, I beg that those minutes be confirmed.
All those in favor say
I'd like
aye.
to second that, sir.
All those in favor say aye.
Aye.
Those against say no. The ayes have it.
Petitions, papers.
So, Deputy Speaker, I am commanded to lay the Barbados Fire Service Annual Report 2016 in the name of the Honourable Minister of Home Affairs.
Mr. Deputy Speaker, I am commanded to lay the Barbados Pork Inc. Annual Report for the year ended March 31, 2017.
Government notices, private members' notices, notices of questions, reports from select committee.
Mr. Deputy Speaker, I beg to move that standing orders numbers 6, 16, 18, 20, 42, 5, 43, and 44 be suspended for the remainder of the day's sitting.
I'd like to second that, sir.
Question is that those standing orders so mentioned be suspended for the remainder of the day's sitting. Those honourable members in favor, please say aye. Those against say no. Methinks the ayes have it. Government business is now the order of the day.
Speaker, order number 8. In the name of the Honourable Minister of Finance, have been introduced by the Honourable Minister sworn in the Ministry of Finance. We move the second reading of the Appropriation Amendment Bill 2018.
Honourable member for Christchurch East Central.
Good morning, Mr. Deputy Speaker. In moving the second reading of the appropriation bill, the amendments to the appropriation bill 2018. This reflects the change in respect of the structure of government to include the finances for the newly created ministries, such as the Ministry of Maritime Affairs and Blue Economy, the Ministry of Information, Broadcasting and Public Affairs, the Ministry of Youth and Community Empowerment, the Ministry of Labor and Social Partnership Relations, the Ministry of Transport, Works and Maintenance, the Ministry of Environment and National Beautification. Mr. Deputy Speaker, the appropriation bill was passed earlier in February this year, and so this morning the Ministry of Finance is just presenting the bill as it currently reflects the structure of government, and so therefore, after the passing of this amendment this morning, the government and the accounting officer should be in a position to discharge of their duties in the manner in which the government has been constructed. And so this amendment this morning, Mr. Deputy Speaker, is simply a procedural measure on the part of the government, but I want to assure the House that the Ministry of Finance, as we have entered into an arrangement with the International Monetary Fund, is in a position to make sure that we're able to maintain the targets, monitor within the respective ministries, such that we're able to execute the program of government over the course of the adjustment period. So, Mr. Deputy Speaker, this is a simple procedural matter this morning, and I therefore beg to move that the bill be read a second time.
Question is that this bill be read a second time. Those honourable members in favor, please say aye. Those against, please say no. Methinks the ayes have it.
Mr. Deputy Speaker, I beg that you do not leave the chair and the House resolve itself into committee for further consideration of the bill.
The question is that this bill, that I do leave the chair, this House goes into committee on this bill. All those in favor, please say aye. Those against, please say no. The ayes have it.
This House is now in committee.
Madam Chair, I beg to move that Clause 1 stand part.
Question is that Clause 1 stand part. All honourable members in favour, please say aye. All honourable members against, please say no. Methinks the ayes have it.
Clause 2.
Madam Chair, I beg to move that Clause 2 stand part.
Question is that Clause 2 stand part. All honourable members in favour, please say aye. All honourable members against, please say no. Methinks the ayes have it.
Schedule.
Madam Chair, I beg to move that the amended schedule be the schedule to the bill.
Question is that the schedule be the schedule to the bill. All honourable members in favour, please say aye.
Aye.
All honourable members against, please say no. Methinks the ayes have it.
Madam Chair, I beg to move that you do not report to His Honour the Deputy Speaker the passing of one bill in the committee with amendments.
Question is that I now report to the Deputy Speaker the passing of one bill in committee. All honourable members in favour, please say aye. All honourable members against, please say no. Methinks the ayes have it.
The chairman of committee has reported to me the passing of one bill in committee.
Beg to move move that this bill be read a third time.
Second. Second.
I beg to second that, sir.
Question is that this bill be read a third time. All those honorable members in favor say aye. Those against say no. Methinks the ayes have it.
Mr. Deputy Speaker, I beg that this bill be now passed and be cited as the amendments to the Appropriation Bill 2018.
Seconded.
Beg to second that, sir.
Question is that this bill be now passed and be so cited. All honorable members in favor please say aye. Those members against say no. Methinks the ayes have it. This bill is now passed and so cited.
Order number 5, sir. Order number 5. Order number 5.
Yes, ma'am.
In the name of the Honorable Attorney General, this bill has been assigned to the Honorable Minister of Energy and Water Resources.
Honorable member for Christchurch East.
Mr. Deputy Speaker, I rise to pilot and spearhead the debate on the amendments to the Offences Against the Persons Act 2018. Mr. Speaker, because we are seeking to abolish the mandatory death penalty, it is not necessary to consider simply the Offences Against the Persons Act and the amendments thereto, but there are other pieces of legislation that will necessarily impact and will have to be amended in order to have the mandatory death penalty under our laws removed, and any amendments make sense. The other acts that are necessary of amendment to achieve this are the Constitution of Barbados, the Penal System Reform Act, and the Criminal Procedure Act. So I propose, with your leave, to treat this as a cognate debate. So while I am substantively debating and presenting the amendments to the Offences Against the Persons Act, my presentation will touch and concern all of the other acts mentioned, so that when we come to deal with those, a debate will not be necessary. It is impossible for me to do otherwise, so I seek your leave to treat this as a cognate debate. I am grateful.
Proceed.
Mr. Deputy Speaker, there are few things in Barbados that evoke... Sorry, Mr. Speaker, I beg to move that this be treated as a cognate debate.
All those honorable members in favor, please say aye. Aye. Those against, please say no. Methinks the ayes have it.
Mr. Speaker, there are very few things in Barbados that capture the attention of the public in Barbados and has generated as heated a debate nationally, in shops, in churches, among gatherings of friends, as the death penalty in Barbados. Now, the debate, for the most part, has centered as to whether or not there should be a death penalty in Barbados. But that is not what we are debating here today. And there seems to be some misunderstanding as to the nature, the exact nature of our debate. Mr. Speaker, we are here to debate amendments to the Offences Against the Persons Act and other legislation, supporting legislation, to remove the mandatory nature of the death penalty in Barbados. That has to be made clear from the very outset, the mandatory nature of the death penalty in Barbados. It is perhaps useful, Mr. Speaker, before I go into the details and particulars of the amendments, to frame this in a way that makes sense. I'm going to take my time with this, Mr. Speaker, because it is not I'm here today not simply to convince my colleagues and to convince the Leader of the Opposition that we should pass the amendment, but it is also necessary that at the end of this debate, the general public in Barbados and anybody listening understands fully how we got here, what it is we are trying to do, the implications for what it is that we are going to do, and the status quo after we have done it. So let us start by putting some context to the debate. Barbados, under its savings law clause, there's a savings law clause in our laws which suggests or which states that any act or any law that existed prior to independence is naturally incorporated into our legislation or laws going forward unless specifically revoked or amended. So if we have passed no other laws touching and concerning a law that existed prior to independence, that law is automatically saved within the laws of Barbados. One such was the mandatory death penalty. We have long defended, successive governments of Barbados have long defended the mandatory nature of our death penalty. The last successful defense of it and the constitutionality of it was in the Lennox, Boyce and Jeffrey Joseph case. And that was before the Privy Council. The Privy Council handed down its judgment on the 7th of July 2004. And although the Privy Council recognized that a mandatory death penalty conflicts with a modern interpretation of Chapter 3 of the Protection of Fundamental Rights and Freedoms of the Individual and other human rights treaties to which Barbados was a party, it upheld the mandatory death penalty as a result of the same savings clause at Section 26 of our Constitution. Barbados also is a member of the Inter-American Convention on Human Rights and the Inter-American Court of Human Rights. On the 20th of June 1978, we signed on to the Inter-American Convention on Human Rights, and on the 5th of November 1981, we ratified it and recognized the jurisdiction of the Inter-American Court of Human Rights. Barbados was one of only 4 CARICOM countries to recognize this court's jurisdiction. However, even in ratifying the convention, Barbados at the time entered reservations with respect to the convention. And one reservation in respect of paragraph 4, sub 4, was that the Criminal Code of Barbados provides for death by hanging as a penalty for murder and treason. And the government is at present reviewing the whole matter of the death penalty, which is only rarely inflicted, but it wishes to enter a reservation on this point inasmuch as treason in certain circumstances might be regarded as a political offense and falling within the terms of Section 4, sub 4. Article 4 of the Convention deals with the right to life. In the case of Boyce et al. Versus Barbados, the lawyers for Lennox, Boyce, and Jeffrey Joseph argued that Barbados violated Articles 4.1 and 4.2 in addition to other articles in the Convention. And in both of the judgments, the Inter-American Court of Human Rights observed that Article 4.2 of the Convention allowed for the deprivation of the right to life by the imposition of the death penalty in those countries which had not abolished it. Therefore, capital punishment was not incompatible or prohibited by the Convention. But it also said the imposition of the death penalty must be limited to the most serious common crimes not related to political offenses. The sentence must be individualized in keeping with the characteristics of the crime, as well as participation and degree of the culpability of the accused. And the imposition of the death penalty must be subject to certain procedural guarantees, and compliance with them must be strictly observed and reviewed. In specifically addressing the mandatory nature of the death penalty, the court held that a reference to arbitrary in Article 4.1 of the Convention and the reference to the most serious crimes in Article 4.2 rendered the imposition of the mandatory death sentences incompatible with such provisions, where the same penalty is imposed for conduct that can be vastly different, and where it is not restricted to the most serious crimes. Let me put this in context, sir. In Barbados, every time an incident or crime occurs that results in the death of a person, with the exception of vehicular manslaughter, the accused person is charged with murder. So that charge of murder applies where a man follows somebody and beats them unmercifully with a piece of board in their head and bashes their brains out. It's sorry to be so graphic, but we're talking about murder. So it's necessary to be graphic. But that same charge would apply in a situation where, let's say, somebody threatened my son, and I took up a piece of board and struck them in the face with it, and they unfortunately died. Now, anyone looking on will see that the circumstances are not the same. In one circumstance, yes, you committed an illegal act in hitting the person with a piece of board in the face, but that you left them standing and you left them walking away would tend to suggest that your intention was not to kill the person, which is fundamentally different from a situation where I beat you until you stop moving. But however, our law as it stands now does not distinguish between those two scenarios, so that the person who did not necessarily intend to kill the victim faces the exact same charge of murder as does the person who intended to kill the victim. And that is what the Inter-American Human Rights Court was trying to get across. We cannot stop you from having a death penalty if that is the rule or the law in your country. Because some cultures, some people, some societies require the option of death as being the final, most severe penalty that the law can impose. But what it says is that that sentence of death must necessarily be reserved for the most heinous of offenses and most serious of crimes, such that no other sentence would suffice. The court further found that the failure of Barbados to amend or invalidate Section 2 of the Offences Against the Persons Act so as to bring its laws in compliance with the Inter-American Convention was a violation of Article 2, and that Section 26 of the Constitution effectively denied citizens the right to seek judicial protection against violations of their right to life. The court felt that all murder should not be punishable by a mandatory death sentence, and consideration should be given by any judge to mitigating or aggravating circumstances when arriving at the appropriate sentence. And therefore, Barbados was found by that court to have violated the convention, and they were ordered to adopt legislative or other measures to ensure that the imposition of the death penalty did not contravene the convention and that the mandatory nature of the death penalty was abolished. We then fast-track to June 2018. The Caribbean Court of Justice, our final court of appeal, and hopefully soon to be the final court of appeal for more of the Caribbean, in its June 2018 judgment in the case of Jabari Nerve and Dwayne Severin versus the Queen, the then Director of Public Prosecutions urged the court to find that the imposition of the mandatory death penalty for conviction of murder in Barbados without mitigation and individual sentencing was unconstitutional. Please note that our own DPP, at that case in front of the CCJ, accepted the unconstitutional nature of the mandatory death sentence. Now, although it took the CCJ to make its final pronouncement, to make it actual law in Barbados, the reality is that the last executions in Barbados took place in, I believe, 1984. And although we have had persons charged with, tried, and found guilty of murder since then and sentenced to death, we have not executed anyone. Because the reality is that successive governments, successive AGs, successive DPPs, and successive rulings of other courts, which we are bound by convention to acknowledge their judgments, have accepted that it is not fair that there should be no option on a finding of murder but to sentence a person to death. A lot of us watch crime movies in the United States, and you hear somebody being tried and charged with murder 1, or found guilty of murder 1, first-degree murder, or second-degree murder, or third-degree murder, or manslaughter. So in other countries that have the death penalty as the final sanction for murder, those countries actually recognize degrees of the offense, with only the most serious degree being punishable by the sentence of death. Why does this matter? Why does this matter? It all sounds like something in abstract until this comes home to roost, until it starts to touch or concern somebody that we know, or until an accident happens or incident happens where somebody we know is killed. Quite often, the family and friends of the victim want blood. They want whoever is responsible to hang. But the flip side of it is the family. Very often, the family of the accused person very often wants that person to get some measure of leniency. How do we balance them? Is our system so infallible that the imposition of a mandatory death sentence is actually appropriate in Barbados? I suggest it is not, for a number of reasons. As I indicated before, no matter the circumstances of the offense, in Barbados, once an offense or incident results in death, the charge that follows that is a charge of murder. Prior, when preliminary inquiries were still the law, very often when the prosecution presents its evidence first before the magistrate's court, effectively to test the evidence, very often, or in a number of circumstances, the magistrate found that while there was enough to sustain a charge, the appropriate charge should not actually be one of murder, but one of manslaughter, because the incidents or the details or the peculiarities of the case or the circumstances of the accused or the behavior of the deceased suggests something else other than premeditated, wanton, and malicious killing. And in circumstances, although the person faced a preliminary inquiry on a charge of murder, after hearing the initial evidence, the court would rule that the charge be downgraded to manslaughter. And the person would then leave the magistrate's court with a manslaughter charge as opposed to a murder charge. Why is that important? Because bail for murder is very difficult. Until recently, you very seldom got bail for murder. Bail for murder was effectively non-existent. Because of delays in our court system, because of inefficiencies, because of inefficacies, we had no choice but to start a practice recently of admitting certain persons accused of murder to bail because their cases were not coming off. And if I sit down on remand for 8, 9 years and my case can't start, then I should be entitled to bail. So at the end of a PI, the man charged or the person charged with murder looked forward or anticipated the decision of the magistrate's court, because if the charge was downgraded to manslaughter, then bail became a consideration. What then happened, Mr. Deputy Speaker, and this is a very upsetting thing, is in the majority of those circumstances, in almost all of those circumstances, although the magistrate reduced the charge to manslaughter and said the matter should proceed to the High Court on the basis of a manslaughter charge, manslaughter indictment. In every instance, the DPP would come back up to the High Court and reinstitute the charge of murder. So we wasted time at the preliminary inquiry. The other thing with that, sir, is that it is unfair to an accused person. Our laws protect everybody on every side. Our laws are supposed to protect everyone in this country. If you were an accused person who your behavior constituted, yes, it probably constituted manslaughter or something else, you might have been prepared to fight that case in the High Court if the case was manslaughter, because there's no sentence of death hanging in your future. If you reach the High Court and the charge is reinstituted as a murder charge, the possibility of death once again is a very, very real factor. And what used to happen is that the Crown would use the sentence, the possible sentence of death hanging over your head, to negotiate you pleading guilty to a lesser offense in order to get the cases off the docket. That was an abuse. It was an abusive situation. Those of us who practice criminal law, who used to practice criminal law, it was a situation where the rights of the accused person was being trampled on the altar of expediency. A man should only be tried for the offense which he committed. He should not be subject to a threat of a higher charge just to simply to get him to plead guilty to a charge which he could have defended. I'm going to make this very real for all of my colleagues and for us listening. And it would explain to you why it is important that we do the right thing and that we abide by the constitutional rights of our citizens. For those of us who've had no contact with the criminal justice system, those of us who do not know anybody personally who was murdered, those of us who do not know anybody who was accused of committing an offense, these words may mean nothing. If you are the person in the system, the circumstances mean a lot. Throughout the entirety of my presentation, and even in the research that many of my colleagues would have done, we kept harping on the fundamental rights and freedoms and the protections against abuses and inhuman treatment. Mr. Deputy Speaker, years ago, about 14 years ago, I represented a man, a young man. He was a drug addict. Some would call him a paro. This man left Nelson Street a day and he was rooting around in the garbage. And inside the garbage in Nelson Street, he found a gun. He took out the gun and walked through Nelson Street trying to sell the gun for $5 because he was just trying to get enough money to get a hit. He went showing everybody and asking people to buy this gun for $5. Nobody would take him on. And he turned and he went down on the beach to smoke some dope out by Boatyard. As he was going onto the beach, two men who he had approached to buy the gun had followed him, and they jumped him by the beach, trying to get the gun from him and to steal the gun from him. In the struggle, the gun went off, and one of the men died, and the other man ran. My client stopped right there next to the dead body until the police came. He didn't know what to do. And he was then arrested, and he was charged with murder. Now, based on what I explained before, that does not satisfy any criteria of premeditation. That does not satisfy any desire to kill somebody. He didn't actually go looking to commit an offense other than selling a gun. But he was charged with murder. He was a psychiatric patient, a drug abuser, and a very fragile person. this boy went through hell. I assured him, and it taught me a lesson, never assure people. I assured the boy, do not mind that you were charged with murder. By the end of your case, it is going to be manslaughter. The other person who jumped him to try to steal the gun gave a statement to the police saying that we followed him, we tried to get this gun from him, we struggled with him, and the gun went off. And he effectively said, he didn't mean to kill anybody, we were fighting him for the gun went off. We went through the entirety of the PI, the evidence of the prosecution was presented, the other fellow who did not get shot came and gave his evidence. At the end of it, the magistrate reduced the charge to manslaughter. That PI took about 20 days. And at every single turn, every single time that fella came into court, he was crying, and he would tell me every single time, Mr. Abrams, don't let them hang me. Don't let them hang me. When the charge was reduced to manslaughter, I said to him, you see, nobody hanging you. He got bail. When he reported for court for the assizes, a year later, they re-indicted him on murder. I remember court number 5 in the old Supreme Court. That's the court downstairs around the back by the car park. That boy bawled when they read that indictment. And he turned to me and he said, Mr. Abrams, you promised me they're going to hang me, they're going to hang me. He left that court, Mr. Deputy Speaker. He went to Glenderry. 2 days later, he was dead. I don't know how he got there. He found himself up on the top of Glenderry and threw himself off. Having a charge of murder where the necessary sentence is death hanging over your head does things to people. It is not fair for us to sit and determine that everybody charged with murder deserves to hang. The police get it wrong. The courts get it wrong. The problem with the execution of a sentence of death is that it is the most final sentence. If evidence comes up later to show that you did not do it, then all the sorries in the world are not going to help. You can't hear them. And I just, Mr. Deputy Speaker, wish to put it in context for you. It is necessary that we actually hear and understand what it is that is pronounced on the person. When you are found guilty of murder in the High Court, it is a very, very somber thing. The prison van pulls up outside, is parked outside before the sentence. It used to be that the judge would come in wearing a black cap to read the sentence and black gloves. But the actual sentence that you hear is that the sentence of this court is that you will be taken from here to the place from whence you came, and there be kept in close confinement. And upon the appointed day, that you be taken to the place of execution, and there hanged by the neck until you are dead. And may God have mercy on your soul. That is what the accused person hears. Now, it is necessary that we fully ventilate this so that the public understands what it is that we're trying to do. From there, when you leave, understand that is the sentence, regardless of whether you bashed a man to death or you were in a fight where the person died and you were found guilty of murder. That is the sentence. There is no time for the reading of the warrant that you will be hanged the following morning. So, from thence, until your sentence was commuted or until you were actually executed, every time you heard somebody coming down the corridor, because those on death row were kept in a separate part of the prison. Every time you heard someone coming down that corridor, outside of the regular times that someone was to come down that corridor, your heart went in your mouth that perhaps they are coming for me. Every time. That is no way to live. The other point there, Mr. Speaker, and that the courts made over and over, and that they did it in the Boyce and Joseph case, was that even if you keep a man on death row, there must be some point beyond which that is now abusive to the person who is serving that sentence. And they deemed 5 years was well sufficient time during which anybody sentenced to death should have all their appeals exhausted, everything dealt with, so that they can either be hanged or be commuted to life in prison. That it was unreasonable, unconstitutional, inhuman treatment to keep someone in that suspended state of panic for more than 5 years. So all of these time frames I am giving are going to have relevance to the amendments in the legislation, but I'm just trying to put you effectively in a full picture as to why this is necessary. Now, understand, Mr. Speaker, we all have our personal opinions on this. I personally have no sympathy, Mr. Speaker, for someone who sets out to kill someone as a malicious enterprise with malice aforethought, who plans and sets it up and ensures that that criminal enterprise is carried out, resulting in someone's death. I have no patience for that person. That is where I apply the Moses law, an eye for an eye. But I believe that is to be reserved for only those people who fall into that bracket where the law has no other option but to take your life, because nothing else will suffice. Now, Mr. Speaker, the CCJ in the Nerve case, the Jabari Nerve and Dwayne Severin case, also felt that the mandatory nature of the death penalty fettered the judge's discretion. Now, under our criminal justice system, the juries are the arbiter of facts. It is open for the juries to decide what are really the facts in the case. They sit down and listen to all the evidence, and they decide, based on the evidence, what fact pattern, what story they can believe. But the judge now is charged with upholding the law and deciding on the sentence. In every other crime, the judge has the discretion as to what sentence to apply. So although you fall short, and although you're found guilty of committing an offense, the judge should have the right to, based on the facts presented in the case or based on evidence that comes after, to be able to apply some judicial discretion and let the punishment fit the crime. We all see in the paper that after someone is found guilty, these character witnesses come forward and people say, you know, he was a good fella, he was under a lot of stress, his father died, something, something, something. Or this person used to beat him and beat him and beat him all the time, and one day he just snapped. And although he killed the person, it's not that he set out to kill them. It is that he couldn't take any more and he snapped. We hear those kind of things, and then the judge listens to all that and says, well, you know, I hear what you say. So as opposed to getting the full weight of the law, you get half the weight. Or I start to take certain things into consideration. I'm going to put it in context again, Mr. Speaker. I was once present in a court if I'm entirely honest, I was actually the attorney for the accused person. This boy had committed 14 robberies. The very last robbery, he shot the person and the bullet lodged close to the man's heart so that they couldn't take it out. So the man has the bullet near his heart up to this day. Now, everybody listening will likely say, well, he deserved to get locked up forever. He robbed 14 people and he shot a man. I am sure that not a person in this chamber is even leaning towards leniency so far for this boy. But after he'd been charged and he was granted bail, eventually, the boy went into counseling. His father, who he was very, very close to, had died. Since his father died, the boy had not spoken a word to anyone. He did not speak to a person. In the States now or somewhere else, they would whisk that boy to therapy, let a psychologist examine him, try to get some help for him. In Barbados, he stopped speaking. He started doing these little robberies nobody knew. And he didn't tell anybody. He only got caught when he shot the man. After he was admitted to bail, we twisted some arms and we got him to see a psychologist and a psychiatrist. The boy got some help. He started to volunteer. He started to do things. He got some CICs. It took a long time for his trial to come on. But he got a whole set of qualifications and tried to turn his life around. He started to communicate again. And he went from being a criminal, a common criminal, to being a model citizen. When the case came up, sir, he pleaded, he did not even bother to fight anything. He decided to throw himself at the mercy of the court. He pleaded guilty to every single charge, so that the court, instead of sentencing him for 1, was there prepared to sentence him for 14. Down the line, some of the people, to be honest with you, came and withdrew. They came and said they didn't want to proceed against the boy. On the very last day, as we were in court, and it was shown how far this boy had come and what he had been through and what amends he was trying to make and what he was trying to do with his life and the other young people that he had helped along the way. The man who was shot was in court. And at the end, when they finished speaking, the man got up and he said, "Can I say something?" Well, to be honest, I was there trying to get this man to not say a word, because I was frightened for the victim to speak. But the man got up and he said, based on all that he has heard, and he has been following the boy's progress, based on what he knows as a fact, if the court wishes to sentence him to imprisonment, let it not be in respect of his case. He is asking the court that imprisonment not be considered for his case, the one where he was shot. And the court eventually put the boy on probation. He did not serve a day. That boy, and I'm deliberately not calling name and not being too specific, that boy is now one of the managers in a very prominent business in Barbados, with a number of people under him, and he has continued up to now to help at-risk youth. The point of that, Mr. Speaker, Mr. Deputy Speaker, is that had the judge not had the discretion to weigh all of the circumstances of that case, then that boy would have been lost away in jail. 14 robberies and 1 shooting, he would have been lost away in jail. So the Inter-American Court and the CCJ and all the other human rights courts make the point that from the time the judge has no other option but to sentence somebody to death, you have stripped away one of the fundamental pillars of our criminal justice system, which is judicial discretion. You've denied the judge the opportunity to take all of the circumstances into consideration and to give the sentence that fits the crime and also the circumstances of the offense. Mr. Deputy Speaker, our system also depends on something called the separation of powers. A lot of people don't actually understand what that is. The separation of powers separates the various arms of government from undue influence into the workings of the other arms of government. The legislature, the executive, and the judiciary. So, the legislature should not actually be giving instructions to the executive as to how to carry out their function. That is why MPs and cabinet ministers are not supposed to get involved with who gets hired or who gets fired in a ministry. But equally, the legislature is not supposed to interfere into the realm of the judiciary. Now, the argument has been made over and over and upheld that if you legislate that if X is the crime, then Y must be the sentence, then that is the legislature interfering into the judicial realm. You can give a discretion, you can give a range, say that the sentence should be between 0 years and 100 years, or 0 years and death. Or you often hear in the drug cases that it can be fined up to $500,000 and or X time in prison, up to X time in prison. They give alternatives. So most of the cases that have heard death penalty cases from Barbados or appeals from Barbados have insisted that the mandatory sentence fetters the right of the judge, the discretion of the judge, and is also a case of legislative interference into the judicial system. So, what I want to hammer home again, I have my own views, but I represent the Cabinet of Barbados, and I represent my constituency. And let there be no doubt that the Cabinet of Barbados has not made a decision to abolish the death penalty. Nothing we're doing here abolishes the death penalty. What we are doing simply is abolishing the mandatory nature of the death penalty and making corrections and amendments to legislation to give effect to that. Now, if we go a little bit further, Mr. Deputy Speaker, it is not as if we had a choice. While we might have delayed in following the dictates of the Inter-American Human Rights Court or following the dictates of conventions that we are signatories to, from the time the CCJ made the ruling that the mandatory death penalty was unconstitutional, the CCJ set out what the new law for Barbados was going forward. So the law was already decided with the decision of the CCJ in the Nerve case. All we are doing now is making the legislative amendment that reflects the decision of the CCJ and making our laws harmonize. So having given that broad overview to try to explain how we got where we got, I am now going to deal specifically with the amendments in the respective pieces of legislation. I start with the Offences Against the Persons Act. The bill we are purporting to debate today would make provision for the repeal of the mandatory imposition of the death penalty for the offense of murder under Section 2 of the Offences Against the Persons Act and for other matters related thereto. So, Mr. Deputy Speaker, Clause 2 of the bill deletes Section 2 of the Offences Against the Persons Act and substitutes a new section. The proposed new Section 2 provides as follows. Section 2 of the bill seeks to abolish the mandatory imposition of the death penalty by expanding the sentencing options available to the court for the offense of murder, pursuant to the decision in the case of Nerve and the Queen. Once again, we restate that the Cabinet has made it clear that the death penalty should be retained as a punishment for the offense of murder. Accordingly, Section 2.1 of the bill, 2.1a of the bill, makes provision for the retention of the death penalty as a punishment for the offense of murder. However, Section 2.1b provides that a person convicted on indictment for murder may also be liable to a sentence of imprisonment for life. The language employed in terms of making the person convicted liable to imprisonment for life should be interpreted in accordance with Section 22(5) of the Interpretation Act, Cap 1. This means that the sentence of life imprisonment is to be interpreted as the maximum sentence of imprisonment that can be imposed by a court on a person convicted of the offense of murder. In other words, where the court deems not that the appropriate sentence is not hanging, but actually imprisonment, then it would indicate the legislation sets out that the person is liable to a sentence for life, but that does not mean they will get life. The court then has the discretion to give them between 0 years up to life imprisonment. So this allows the court to tailor the punishment to fit the crime and to take into account the particular characteristics of the crime and the participation and degree of culpability of the defendant. Section 2, Part 2 sets out the circumstances in which the court may impose the death penalty on a person convicted for the offense of murder. So if we go to Section 2.2, a court may sentence, this is brand new. This is what the court has to factor into when making the sentence of death. A court may sentence a person convicted of murder to death where A, the murder was committed with a high level of brutality, cruelty, depravity, or callousness. B, the murder involved calculated or lengthy planning. C, the deceased was a judge, a magistrate, the director of public prosecutions, or a legal officer in the Department of Public Prosecutions, and the office of the deceased was a factor in the commission of the offense. D, the deceased was a member of the Royal Barbados Police Force, the Defense Force, a member of the Special Constabulary, or prison officer, and the office of the deceased was a factor in the commission of the offense. The deceased was a member of a group of persons who have a common characteristic such as race, nationality, ethnicity, or religion, and this was a factor in the commission of the offense. F, the deceased was a witness or a juror in a pending or concluded trial, and this was a factor in the commission of the offense. G, the deceased was particularly vulnerable because of his age, health, or disability, or because of any other factor. H, the person convicted was convicted of 2 or more offenses of murder, whether or not arising from the same circumstances. Or I, in the opinion of the court, there are any other exceptional circumstances which must be taken into account and which justify the imposition of death. If you look at the criteria for the imposition of the death sentence, the large part of it, the bulk of it, involves some measure of premeditation. That it was not a random offense, that the person who was killed was targeted by virtue of there being a judge, a magistrate, a police officer, prison officer, of a certain racial orientation, etc. So in this case, it imputes a level of thought, premeditation, and execution on the part of the person who committed the offense. This is brand new, and this is what the judge has to sit down and run through all of this. look at all of them, look at the criteria, weigh up the criteria, and decide, based on all of the stated criteria, whether or not death is the appropriate sentence. Section 2.3 takes into consideration decision in Pratt and Morgan. Thus, Section 2.3 requires that where the court sentences a person to death, that sentence must be executed within a 5-year period, or the risk being in breach of Section 15 of the Constitution, which seeks to protect a person from being subject to torture or inhuman or degrading punishment or other treatment. Where the sentence is not executed before the expiration of the said time, the sentence must be commuted to a punishment to be determined by the court, having regard to the guidelines set out in Section 39 and 41 of the Penal System Reform Act. So, in my lead up, before I got into the meat and bones of the particular amendments, I had indicated that the precedents had leaned towards suggesting it was unreasonable to keep a person on death row for more than 5 years. And our amendment seeks to codify that, to take it out of the realm of suggestion and put it firmly into law, that we must get our system, our court system, in order such that we are able to properly prosecute matters, and the court system must be efficient enough to take a person from sentence to the exhaustion of his last appeal within 5 years. If we, as a government, and the Chief Justice, as the leader of the court, the Chief Administrator of the courts, cannot manage to get our court system running to a point where a man can have all of his appeals exhausted and heard within 5 years, then that sentence must be commuted from a sentence of death to something else. And the court gets to look at what that something else is. The other thing, Section 2.4 enables the court to impose a sentence of imprisonment for life on a person convicted of the offense of murder. The CCJ has indicated in the case of Gab versus the Queen that a sentence for imprisonment for life should not prohibit the possibility of parole. If the provision does so, it is unconstitutional. So, Section 2.3 provides for the imposition of a sentence of imprisonment for life on a person convicted of the offense of murder, but allows the court to set a minimum time that must pass before the person be considered for early release. When we watch the same court movies on TV and they hand down the sentence, they say a sentence of life imprisonment without the possibility of parole for very heinous crimes, or they sentence you to 30 years, but you cannot have a parole hearing before 10 of them have expired. It gives the judges, the judiciary, a chance to reevaluate and make recommendations based on the progress of the person. Our penal system is not meant simply to punish people. We also look at rehabilitation of the offender. We look at compensating the victim. So if one of our factors is the rehabilitation of the offender that we have to take into consideration, it is not simply good enough to tell a man, I sentence you to 30 years and don't look back at him for 30 years. Imagine in that 30 years, that man has been the model prisoner. He has saved a life. He has found the Lord. He has written books. He is publishing from the prison inspirational messages that are keeping young people off. He's participating in prison programs aimed at trying to convince young people to stay out of crime. Then there should be some avenue to look back at that man's sentence and say, although you were supposed to be there for 30 years, based on everything that you have done, we think you might be good to go home after 20 or 15. It has to be a necessary factor. Otherwise, what incentive is there for anyone who enters the prison system to try to do better? if I have to serve out every day of my sentence without the possibility of the circumstance of my incarceration being taken into account, then there is nothing at all there that would motivate me to try to help a young person in prison. There's nothing there that will motivate me or inspire me to try to be a big brother to somebody else. And imagine if I can help 10 people in jail who might have passed through from minor offenses to turn away from crime. And I'm so committed. Imagine how much better I can do on the outside before they actually reach the jail. So all these things have to be factored. So I welcome and applaud the steps that we are taking, because it goes with the shifting concept of sentencing. It is no longer the Moses law. It is no longer simply an eye for an eye or cut off the hand. It is you are sentenced, but within the parameters of your sentence, you can work to try to do better. And we have to recognize when you have actually tried to do better and when you have actually done better. Also under the Offences Against the Person Act, there's provision in here, Mr. Deputy Speaker, that for all persons who were convicted, who were sentenced to death prior to the passage of this legislation, if we are now saying that the death sentence is unconstitutional and the mandatory death sentence is inhuman and degrading punishment, we can't simply change the law now going forward. If it is unconstitutional, it's unconstitutional. It's not unconstitutional going forward. It will have to be unconstitutional to those who are already under a sentence of death. So the Offense Against the Person Act makes provision as well that all their sentences have now to be commuted, and the persons under the sentence of death have to have those sentences reviewed and the appropriate sentence given. Now, prior to this amendment, I think the only discretion that there was in the Mercy Committee was to commute, Her Majesty's Privy Council was to commute their sentences to life imprisonment. I'm seeking clarification from the member for Christchurch South. I believe that was the only discretion, to commute their sentences to life in prison. So, bearing in mind that there was no discretion other than commuting from death to life in prison, where you have actually been, your sentence has been commuted from death to life in prison, now with this amendment, you also have the opportunity to have your sentence reviewed and the appropriate sentence put in place. So everybody who was once under a sentence of death, whether it has been commuted to life imprisonment or whether you're still under death sentence, with the passage of this legislation, everyone will have their sentence reviewed. It will be, death sentence is off the table for all you who have been sentenced before this amendment. And your sentence will then be reviewed as to whether it should be life or whether it should be something else. That, Mr. Deputy Speaker, is pretty much the nuts and bolts of the Offences Against the Person Act. The thing is, it does not stand on its own. We necessarily need to amend the Constitution, from which all the other legislation derives its efficacy. So we are seeking to amend the Constitution as well by deleting the provision in Section 15 that authorizes the mandatory imposition of the death sentence for the offense of murder, redefining the effect of the existing law clause in Section 26, and refining the exercise by the Governor General of the prerogative of mercy. So I will take us through, not that many, I'll take us through the amendments. Section 15 of the Constitution, the existing Constitution, is repealed, is deleted, and the following is substituted. No person should be subject to torture or to inhuman or degrading punishment or treatment. Nothing contained in or done under the authority of any law shall be held to be inconsistent with or in contravention of this section, to the extent that the law in question authorizes the imposition of a death sentence or the execution of that sentence, or the holding of a person who is in prison or otherwise lawfully detained under conditions or arrangements prescribed by law under the Prisons Act, or under any other law pending the execution of death of the sentence of death in accordance with any other sentence of the court. I think that's pretty much self-explanatory. Section 26 of the Constitution, which is the existing law clause, has also been amended that the existing law shall continue to be enforced but shall be construed with such modifications, adaptations, qualifications, and exceptions as may be necessary to bring it into conformity with sections 12 to 23 of this Constitution. That is also self-explanatory. The prerogative of mercy now reads, that is section 28, clause 28 of the Constitution, the Governor General may, in Her Majesty's name or on Her Majesty's behalf, grant to any person convicted of an offence against the law of Barbados a pardon, either free of or subject to lawful conditions. Grant to any person a respite, either indefinitely or for a specified period of time from the execution of any punishment imposed on that person for any offence. Substitute a less severe form of punishment for that imposed on a person for any offence, or remit the whole or part of any punishment imposed on a person for an offence, a penalty or forfeiture otherwise due to the Crown on account of such an offence. The Governor General shall, in the exercise of the powers conferred on him by subsection 1, or any other power conferred on him by any other law, remit any penalty or forfeiture due to any person other than the Crown, act in accordance with the advice of the Privy Council. Where a person makes a submission in accordance with subsection 5, in respect of offence against the laws of Barbados, the Governor General shall cause a written report of the case from the trial judge, together with such information derived from the record of the case or elsewhere as the Governor General may require, to be forwarded to Privy Council so that the Privy Council may advise him on the exercise of the powers conferred on him by the subsection 1 in relation to that person. A person has a right to submit directly or through legal or other representative without representation in relation to exercise by the Governor General or the Privy Council of any of their respective functions under this section. And a person may, in appropriate circumstances determined by the Governor General or the Privy Council, be granted an oral hearing and may make oral submissions directly or through a legal or other representative in relation to exercise by the Governor General or the Privy Council of any of their respective functions under this section. What that section actually effectively does is repeal and replace section 78 to remove the Governor General's capacity to direct that there should be time limits within which any person may appeal to or consult any person or body or person other than Her Majesty and Council outside Barbados in relation to an offence. So the time limits are necessarily addressed in the Offence Against the Person Act, which I went through before, and effectively suggests that if you don't execute the person within 5 years from the time you sentence him, then it can be commuted. That was pretty much the crux or the import or what informed all the other time limits with respect to appealing to the other bodies or to the Supreme Court or to the Court of Appeal. The Penal System Reform Act as I indicated before, there are certain sentencing guidelines that the judge has to take into consideration. The Penal System Reform Act is what the lawyers use as a mitigation, the law relating to mitigation for their clients. They look at the Penal System Reform Act and the criteria that the judge is supposed to take into consideration, and then they would mitigate for their clients based on the provisions of that piece of legislation. So we have to amend the Penal System Reform Act in order to give efficacy to the amendments within the Offence Against the Person Act and also the Constitution. The sentencing guidelines set out in sections 31 and 41 of the Penal System Reform Act apply to offences, the sentences for which was discretionary. The new Offence Against the Person Amendment Bill will change the status of the sentence for the offence of murder from one that is fixed by a mandatory sentence to one that is discretionary in nature. Thus, the sentence imposed for murder can be tailored to fit the circumstances of the case and the individuality of the offender. As a consequence, the aforementioned amendment, it was determined that it was necessary to amend sections 31 or 41 of the Penal System Reform Act to ensure that they apply appropriately to the offence of murder. I would actually have listed most of the criteria in my address on the amendment to the Offence Against the Person Act, But Section 39 says that the court is bound to consider certain mitigating factors. Nothing in this act prevents the court from mitigating an offender's sentence by taking into account such matters as, in the opinion of the court, are relevant considerations with respect to the mitigation of a sentence, including. So what I'm about to list here are the factors that the court should consider before passing its sentence. So these can mitigate you down from life imprisonment to something else. The age of the offender, the particular circumstances of the offender, such as his social or economic circumstances, whether the offender pleaded guilty and the point at which the guilty plea was made. I pause here for a second. It is standard, and it has been the law in Barbados and in the common law, that a judge is bound to take into consideration in passing sentence a guilty plea, because it shows that the person acknowledged their mistake and exercised some contrition. What the judge also has to factor is the time at which that plea is made, because an accused person could change his plea to guilty at any point in time in his trial before the verdict is pronounced. What the court factors is, if I as the accused person, am sitting down there thinking to myself, I could probably get off of this, and then I realize that 15 witnesses coming up, all of who say they saw me, and then the last one was actually my mother, who said, yeah, trust me, I saw him, it was him. And I then decide, okay, well, if my own mother testify against me, there's no way of getting off, so let me ease in my guilty plea quickly. While the court may take that guilty plea into consideration, it obviously does not carry the same weight as, for example, the youngster that I spoke about, who had the 14 convictions, who had the 14 charges, who on the first occasion before the court pleaded guilty to all of them. So there's a difference to be considered there. And the amendment to the section codifies that. The circumstances or facts of the offense and the degree of the offender's involvement in the offense, and any attempt by the offender to make reparation for the offense. Now, our laws try to achieve equality in sentencing, or in sentencing for offenses. So what used to happen, sir, was if 4 of us, actually let's not say 4 of us, let me not impute myself in criminal behavior. If 4 people set out to rob a man, and one man had a gun, and I went there intending to get a watch from off the man, but I didn't want to hurt him. And as we struggling to get off the watch, my partner, you see, I back to put myself in it. So I can put myself in and call some names too. So if myself, the member for St. Philip West, the member for St. John, and the member for St. Michael West, I put in leader opposition in it too. If we settle on a criminal enterprise, and somewhere in there, all of us were going to rob a man. But none of us knew, for example, that the member for St. Michael West had a gun. And the man then got shot and died. What would happen normally is something called joint enterprise. The law said we all set out to commit a criminal act. At the end of the day, somebody died. All of us are guilty of murder. This is why I would never hope to see the member for St. Thomas on a jury. But what this says now is that it looks at the culpability of each offender separately. So in this circumstance now, instead of all of us being found guilty of murder, it might be the member for St. Michael West who might face that by himself. While the member for St. John, who actually drove the car but didn't know we were going to rob anybody, he knew we were up to no good, but he didn't know what was going to happen, he might get off. While myself, I'll be getting off with him. And the member for St. Philip West might have to do 10 years with the possibility of parole after 5. So you see how we're now harmonizing it to bring it in line with the modern thinking with respect to penalizing for offenses. And
As stated.
I will also show how this correct some anomalies. In the same case of Joseph and Boyce that would have gone to the Privy Council, there were 4 young men who were charged. Well, I can say the facts. The facts are there. They're a matter of record. There was a young man, the deceased man, I think his name was Hippolyte. He had, the facts bore out that he had seen these men on a bus and seen one of them on a bus and he threw a rock in through the window of the bus. The man got out and went looking for him. And they found him and they started to beat him. Somebody threw in some kicks, then somebody picked up a piece of board and hit him with it. But they left him there. But he got up within their sight and he went to a house for help. So they watched him walk away and go to that house. He subsequently succumbed to his injuries and died. 2 of the men pleaded guilty, took the plea for manslaughter and pleaded guilty, while 2 sought to fight the case because they believed that they were the least culpable in the whole thing. So what ended up happening was 2 of the men, I believe, got 12 years, got a certain amount of time, and 2 of them were sentenced to death. So it cannot be that we have these anomalies. We need to correct our legislation that removes these possible anomalies. Because in a situation where those 2 men took a plea and got 12 years or got sentenced for the manslaughter, now with the court hearing the whole matter through, and the court hearing that maybe these 2 men who actually fought the matter were not the most culpable and actually should not be sentenced to death, the court now will be able to say, let me adjust their sentence, or let me sentence them that it does not create a disparate situation with the sentence of the other 2. As the law stood before, once they were found guilty of the murder, that discretion was gone from the judge. So you had 4 men in one enterprise. 2 men plead guilty and got a term imprisonment, and 2 men were sentenced to death. So this corrects all of that. So the judicial sentencing guidelines are explained, but these are the same. All right, so in sentencing the offender, the court should take into account the following guidelines. So not this, you address your mind to the mitigation first. So you check off your mitigation points, and then you address your mind to the sentencing. In sentencing the offender, the court shall take into account the following guidelines: the gravity of the offense and the need to hold the offender accountable for the harm done to the victim and the community by the commission of the offense. Any written representation made by a spouse or relative of the deceased in respect of murder or manslaughter, and in any other case, any written representation from the victim. So this allows those affected, either the victim or his next of kin or whatnot, to actually have a say to make representation before the sentence is passed for the judge to take it into consideration. It works 2 ways. Because in an offense, let's say of, let's take it from murder, let's say of wounding. If the family comes forward or the victim comes forward and gives evidence and says, look, although he pleaded guilty, so the fact's not before you, this man stalked me and followed me, and he beat me once, and he beat me again, and I went to the police, and then he followed me again, and then he beat me, and we know here. The court can take that into consideration. But equally, the court can also take into consideration like what happened that I had alluded to with the robberies, that the victim says, I don't want him to do time on my behalf. So this now is included in the sentencing guidelines. Ensuring the court must also ensure that the gravity of the sentence is commensurate with the nature of the offense committed by the offender. So that as well flows with respect to murder. That is the ultimate case where the sentence is commensurate with the actual offense. Because if I chop off your hand and I get time for it, I mean, my serving 5 years cannot replace your hand. But the ultimate sentence of taking a life to satisfy the fact that a life was taken is factored here as well. And it has to necessarily be factored to give, once again, effect to the fact that we're having levels now of murder. So the judge can factor that into, was this crime so heinous that the only answer is the ultimate sentence? Or if you go for lesser sentences, is the crime so heinous that the person should get at the maximum end of the scale? The judge must also factor the need to deter the offender and others from committing similar offense. So that's when the judge institutes a sentence to send a message. The manner in which the offender executed the offense and the nature and duration of the relationship between the offender and the victim, that is self-explanatory. That would normally factor in a circumstance. For example, if a parent is abusing a child or an uncle troubles his little niece or something. The degree and culpability of the offender and the maximum penalty prescribed for the offense. This is likely to be applied in cases where there are more than one offenders, and rather than pay everybody the same brush, you separate them as to their involvement in the crime. Any attempt on the part of the offender to make reparation to the victim or the victim's family, we're looking, as part of our sentence, to order also a compensation regime, because the reality is, if the member for St. Philip West cuffed me in my face, I may prefer to take $10,000 from him as compensation for the injury and my embarrassment than see him go to jail for a year. So it will allow for that. The need for rehabilitation of the offender and the need to promote a sense of responsibility on the part of the offender for the harm done to the victim. This one is directly to the offender. The need for consistency in sentencing in respect of similar offenses. And it should be the case that a person facing a charge or facing a trial should be able to predict the sentence he is likely to get. If I know that somebody broke and entered a house and stole a bed and they got 2 years, then I should also know, if I stole the bed, that I'm looking at 2 years. As opposed to one judge gives 2 years, and another gives a $1,000 fine. And the possibility of providing restitution for the harm done by the offender. That is self-explanatory. I'm coming home now, I'm soon there. The last bill we look at is the amendment to the Criminal Procedure Act. And the short form of this, the amendments that we are seeking makes provision, it creates a new section 6A, which makes provision for a person who is to be arraigned upon an indictment for the offense of murder to undergo a psychiatric evaluation to determine whether that person is fit to plead. As it stands now, that is not in our law. But because of the ultimate sentence, you have to make all the necessary safeguards. So any person who is supposed to be arraigned and face a trial for murder, the court must send that person now for a psychiatric evaluation. And clause 3 inserts a provision to allow judges to intervene where the defense of insanity and diminished responsibility should be raised in relation to an accused. So where a judge, this one bears listening to, because it allows the judge to interject and intervene and effectively interrupt the course of the trial. Where a judge determines from the circumstances of the case raised before him that the defenses of diminished responsibility or insanity should be raised in relation to an accused, the judge shall order that the accused undergo a psychiatric evaluation to determine whether the mental status of the accused would support the submission of arguments for diminished responsibility or insanity in relation to that accused person. Where the results of the psychiatric evaluation referred to in subsection 1 indicate that the defenses of diminished responsibility or insanity should be raised in respect of the accused, the judge shall ensure that the defenses are raised in relation to the accused. So what this says is where a judge is hearing a case and it becomes obvious from the evidence before the judge and from the disposition and the presentation of the accused person that that person is likely suffering from a mental disability or does not have full mental capacity, then the judge can order that they be evaluated by a psychiatrist. If the psychiatrist then finds that the person is of diminished responsibility, it will be unfair to allow the case to continue as if the person was a fully whole person, because they may not be able to defend themselves properly, they may not have been able to give proper instructions to their lawyer, and in keeping with trying to balance the rights of the accused as well as the rights of the victim, it is necessary that the judge retain the discretion to intervene in there to ensure that all defenses available to the person are raised. So, Mr. Deputy Speaker, I am sorry that I have taken this long. Actually, I'm not sorry. I'm not sorry at all. It was necessary, Mr. Speaker, for me to take this long to present this bill and these amendments. Because, as I said, it is not sufficient that these amendments pass if people do not understand what has happened. Let it not be that the public of Barbados leaves this hearing or switches off at the end of our debate and believes that the death penalty has been abolished in Barbados. It was also necessary, because of the nature of this debate, to take us through all of the other pieces of legislation that might be impacted, because the consideration of the mandatory death sentence occurs in many different pieces of legislation, ultimately with the Constitution. But it is not sufficient to just take it out. You have to take it out, but still empower the judges to make other determinations. You have to take it out, but still direct the judges as to mitigation circumstances. You have to take it out, but also adjust the discretion and the remit of the Mercy Committee. So it was necessary for us to go through all of the pieces of legislation so the pieces drop into place. At the end of it all, and after the successful amendment of all of the relevant pieces of legislation, the net effect will be the following. The mandatory death sentence in Barbados will be abolished. On a finding of guilty of murder, the judge will have a discretion as to what sentence to apply and guidelines for consideration as to how to arrive at that sentence. The judge will therefore have the option of sentencing the offender to death in the most heinous and egregious of circumstances where there is no other penalty under our law that will satisfy the balance of the victim, the society, punishment, retribution, having consideration for all of the factors which must be taken into consideration. The judge can decide that the only sentence that suits this particular crime, because of its nature and because of the behavior of the accused person, is death. But the judge also has the discretion where he finds that the circumstances do not warrant a death sentence to impose some other sentence. Because we are making the amendments now, they will necessarily affect some of those or some people who are currently under a sentence of death. So where a convicted person was under a sentence of death, whether he's still under the sentence of death or whether his sentence of death has been commuted to life imprisonment, that person is now entitled or must have their sentence reviewed, and the judge reviewing the sentence must apply the guidelines that were specified in the legislation. We have now brought our laws in conformity with the bulk of the human rights conventions, and also we have brought our laws in harmony with the decision of the Privy Council in the most recent case of Nerve, so that while we retain the right to sentence someone to death, it is not automatic, and the other factors have to be taken into consideration. And we also acknowledge and uphold in the Constitution the rights of the individual to be protected, have their rights, human rights protected from arbitrary, unreasonable, inhuman, and degrading treatment. So what we are putting before you today is the amendment to the Offences Against the Person Act, along with the reasoning and rationale for the amendments of the other act to harmonize those, so that our laws, our written legislation will now come in conformity with the law as it now stands, following the decision of the CCJ, which is our highest court in the land. I hope, Mr. Deputy Speaker, that those who are listening now have a fuller appreciation and understand why we are doing what we're doing, that it is necessary, that it is correct, that it is appropriate. I want to thank the drafters of the law, because in addition to the drafting, the explanatory memorandum at the back of the legislation is perhaps some of the most thorough explanatory memorandum I've ever seen in the back of legislation. And anybody who chooses to go on our website, Parliament of Barbados website, you can pull up the legislation. You can actually read the explanatory memorandum for yourself, which is at the back of the legislation, and it sets it out chapter and verse and explains why it was done and the impact of it. So, having said all of that, Mr. Deputy Speaker, I beg to move that this bill be read a second time.
Thank you. Member for Sir Michael West.
Thank you very much, Mr. Deputy Speaker. The honorable member who just took his seat, having addressed this honorable chamber, is reputed in Barbados and in the region as a very highly skilled legal practitioner before the bar. He's regarded by many as a very good orator. I heard that comment this very morning from someone who just noticed him in passing. But he's a very poor judge of character, Mr. Deputy Speaker.
In what way?
In what way? Well, he introduced this hypothetical scenario of four of his colleagues, three of his colleagues, four of us in this honorable house, who embarked upon some imaginary crime. And he sought to put the gun in my hand. He must be a very poor judge of character. Because I think he included the Honourable member from St. John in that four, and the Honourable member St. Philip West in that four. And I think he included himself. But yet he put the gun in my hand.
He put the gun in your hand.
He's a poor judge of character. Obviously, the presentation was intended to not only introduce these very important amendments to our existing legislation, but the presentation was attempted in a way to ensure that the Barbadian public became fully seized as to the nature of the action being undertaken by the House today, and the intentions of the government with respect to these amendments, and I think effectively presented. Obviously, a move, Mr. Deputy Speaker, to conform to the emerging laws, the emerging trends with reference to the practice of judicial matters in the region and even beyond. The attempt to amend the Constitution to provide for the discontinuation of a situation where there is imposed a mandatory sentence upon conviction, a mandatory sentence of death upon conviction for murder. The amendment to the Constitution to give effect to that occasions, as we have been well informed, other related amendments, penal system reform, criminal procedures, offenses against the person act, and stuff like that. So it is clear the context in which the amendment is being attempted from a legislative perspective. 2/3 of the established and recognized states of this world have not carried out a death sentence in about a decade. So there is a trend to move away from capital punishment as a mandatory sentence in response to a conviction on murder. More than half of those states have abolished the death penalty entirely, altogether. The understanding here that this is not the case in Barbados, this is not what is being done. We are removing the mandatory death sentence upon conviction for murder. In the buildup of case law in the region, and much of it cited by my learned friend from Christchurch East, suggests that the mandatory sentence of death upon conviction for capital murder breaches the constitutional provisions in relation to human rights and in relation to the right to life. These things are enshrined in our Constitution, have come under scrutiny and challenge, and now successfully so. Hence, we are here today in order to effect these necessary changes. Those trends, those developments with respect to the advance of the judicial practice across the region, the decisions which have been handed down thus far, some of which were alluded to by the honourable member who last spoke, highlight the inconsistency of that mandatory sentence as a penalty for murder when put against the matter of prohibition of inhuman and degrading treatment. Prohibition of human and degrading treatment. All we are trying to say here from this position is that we understand what this government today is trying to effect in this parliament is in keeping with trends with respect to the dispense of justice across the region, and specifically in relation to the capital crime of murder. Ultimately, our highest appellate court, the Caribbean Court of Justice, has ruled in the case cited by the honourable member for Christchurch East and the lead spokesman on this presentation today, that mandatory death sentence, in fact, does contravene the right of convicted capital offenders to the protection of the law, since it denies what is considered to be a critical, essential in the dispensing of justice, that is judicial discretion. And hence, as I understand it, we want to provide for judicial discretion upon conviction of offenders for the capital crime of murder. The honourable member in his presentation referred to the ruling of the Inter-American Court. I took note of that. And Article 4 of the Convention of the Inter-American Commission on Human Rights, which addresses the issue of arbitrary deprivation of life, suggests that I think he may have referred to some of this, I quote some of it myself, Mr. Deputy Speaker. In Barbados, the purpose of statutory and common law defenses and exceptions available to defendants in death penalty cases is to defend the innocence of the defendant, not to determine the appropriate punishment once the defendant has been convicted. Though defendants have the right to apply to the executive branch for amnesty, for pardon, and for commutation of sentence, courts still have a responsibility to impose the most appropriate punishment for particular crimes. This is taking a position against what obtains in Barbados even until now, until this legislation before this House comes into effect. And Article 4.2, limitations on the death penalty of the Convention, reserves capital punishment only for the most serious crimes. Section 2 of the Offences Against the Person Act contravenes the Convention because it requires the indiscriminate application of the death penalty as punishment for conduct that can vary tremendously, as my honourable friend tried to illustrate. The imposition of a mandatory death sentence in the case of the Costa Cadogan, therefore, violated his right to life. And this is the document related to that document for which my honourable friend had quoted. But arguably, Mr. Deputy Speaker, I would also want to put on the table and in the mix for balance that though those who are found guilty of murder perhaps should not find themselves mandatorily faced with a sentence of death because certain rights are enshrined in our Constitution and other bits of our legislation that guarantees them right of protection and right to life and safeguards against degrading and inhuman treatment and all of that. Arguably, we must also consider that these things must be subject to the rights and freedoms of others. Because at the end of the day, we must never lose sight of the fact that no matter what my rights might be as constituted legally, when I infringe on the rights of others, I imperil myself and run the jeopardy of losing some of those rights. And I'm just trying to say that while we discuss this and while we understand where these trends are taking us and why we're here today and doing what we're about to do, we also have always to ensure that we do not lose sight of the fact that my rights are not at the expense of the rights of others. So he who murders may be subject to some rights and safeguards despite murder, however we qualify that murder. But he who murders and is subject to that qualification must also bear in mind that those who are victims are also do have rights, and we should never lose sight of that as a society. The right to life, the right to liberty, the right to security. Now, we understand that we must make an amendment to Section 2 of the Offences Against the Person Act, and that will have to be amended to accommodate removal of the mandatory death sentence and to provide for expanded sentencing options. I think that is ultimately the intention. Now, I support strongly and wholeheartedly the Cabinet's insistence that we retain the option of the death penalty. And I simply seek to reinforce what the Honourable Member tried effectively, I think, so to do, that Barbadians understand that we are not about abolishing the possibility of a sentence of death on conviction for capital murder, simply expanding the options. Now, often, Mr. Deputy Speaker, the question is asked, is the death penalty really a deterrent? Now, there are many who come from the church who strongly believe that we ought not, as a modern society, a modern state, to have on our statute books capital punishment of death, even for the most brutal murders. because they attach a sanctity to life, which they believe overrides the state's authority to take life itself. And they take a negative view of any society or state authority which seeks to retain and exercise that right to take life as a punishment, as a sentence for the commission of capital murder. But I have a very simple view, Mr. Speaker, as to whether it constitutes a deterrent or not. They say the statistics, when you research them, will say it does not. They say if you check in any region of the world, you find that capital punishment does not deter persons from committing murder. Well, I don't know about that. I have a very simple view of this matter, Mr. Deputy Speaker. And if I know well the honourable member for St. Thomas, I am sure she will concur. A very simple philosophical frame within which I look at these things. There are those who will commit murder, whether or not there is a death penalty. And so a death penalty will not deter them. There are those who will not ever commit murder under any circumstances. So the death penalty sanction does not apply in their situations. But I'm sure you will agree with me, Mr. Deputy Speaker, there are those who, were there not a death penalty, would commit murder in given circumstances, and that the death penalty serves as a deterrent to them, and those we must deter. There are only three types of persons: those who will kill no matter what, those who will never kill no matter what, and those who will kill where they're not deterred from so doing by the retention of a death penalty. So I support strongly the view of the Cabinet that that must stay in place as an option of sentence for the court. And if ever we feel challenged strongly to remove, as a government, as a people, the death sentence in response to conviction for murder, that it be made the subject of referendum in Barbados. That's one of the things I do not think that 23 or 26 or 15 people in the cabinet room should decide. It's not something that 30 people in an honorable chamber such as this is, however configured, whether 29-1 or other, I do not think that that kind of issue should be settled in that context, and that therefore, if ever there is such pressure from the outside, internationally or regionally, if ever there is such a push from the inside, locally, that we abolish totally the availability of the capital sentence to the court, that we make that a subject of referendum. But, Mr. Deputy Speaker, we need to do the necessary. When people are convicted of murder, especially under the anticipated context, where mandatory death sentence does not now apply, we need to make sure that we do things in such a way that those, very strong on this too, those who attract the ultimate sentence, the mandatory sentence from the court, when all things have been considered, that we put our judicial process, our judicial architecture in such a state, put it in such a state, get it in such a state that we can expedite the matters of justice quickly as possible. All I'm saying, it is good that as a society in this modern day, progressive as we are, we can come to this chamber and effect such changes as would remove those stipulations which we believe impinge upon the rights of persons, even those convicted of murder. But even as we do that, when once a person attracts the mandatory sentence attracts the maximum, the ultimate sentence from the court in relation to this crime, we need to make sure that we expedite execution of that sentence in a sufficiently proper time, as that we do not make a nonsense of the courts and of the process of justice in Barbados. We all know where it started for us with the Pratt and Morgan case of several years ago, and I have parts of that here to which I want to refer because it's a serious thing. And all I know, we live in the face of the consequences of a system of justice unable to carry out sentences determined by the court because we do not ensure that mechanisms to effectively and appropriately, quickly expedite these matters are in place. On the 9th of July, 1987, the Inter-American Court of Human Rights, pursuant to further representations of Pratt and Morgan, informed the Jamaican government of the following findings. Pratt and Morgan suffered a denial of justice during the period 1980 to 1984, violative of Articles 5.2 of the American Convention on Human Rights. That's the position they took. Commission found that the fact that the Jamaican Court of Appeal issued its decision on December 5th, 1980, but did not issue the reasons for that decision until 4 years later, September 24th, 1984, was tantamount to cruel, inhuman, and degrading treatment because during that 4-year delay, the petitioners could not appeal to the Privy Council and had to suffer 4 years on death row awaiting execution. The Trinidad government, some years ago, put in place a management commission intended to serve as a mechanism to expedite these matters so that once a sentence is given at court and the accused is allowed all of his appellate rights and the processes are gone through, the judgment of the court can stand and the sentence can be carried out. You are old enough, Mr. Deputy Speaker, to remember this. That is why Dole Chedi and his gang are no longer with us, because the Trinidad government, the state, moved as quickly as possible to put mechanisms in place to expedite the sentences handed down in the court. So we're going to expand the sentencing options, and we're going to provide for relief for persons in consideration of their rights and so forth. We also have to so equip the system and so expedite matters that once appellate rights are exhausted, the sentence of the courts can be carried out, and people, some elements in Barbados will not be of the view, I can kill because all I gotta do is go up there after a while, 10 years, 15 years, get fed, and come out. And that is part of the thinking that obtains among certain elements in Barbados. So we need to improve the technical capacity of the courts, and we need to remove all the obstacles to efficiency so that justice can be dispensed evenly, fairly, but as swiftly as possible. Justice delayed is justice denied, not only to victims, and not only to offenders, but to the entire society. And that is the terms in which I see things, Mr. Speaker. That when the offense of murder is committed, it's not just one individual against one individual, but it is an action against the state, against the society, against our domestic humanity, if I may put it like that. And therefore, those things may be seen, must be seen in those terms. I have to ask, and I do not know who is equipped to answer, but where are we with forensics in Barbados and legislation relative to the use and employment of forensics? Where are we in Barbados with reference to the matter of the use platforms for DNA and the legislative framework among maybe the legal minds on the other side can tell me, and perhaps by extension tell the public, because we take stress from the world. We are made sometimes to address ourselves to those trends introduced by them, and pressure is put on us to comply and conform. And that is part of the world system. That is where we are. That's the nature of life in this world for states today. But I also think that we need to take cues from them as to where they have gone in improving and better equipping their justice and law enforcement systems. So my question really is, where are we in Barbados today, both with respect to the legislative frameworks and the use platforms for things like forensics and DNA? Now, I do not know, Mr. Speaker, that we can continue for much longer simply relying on, if that's what we're doing, as seems to be the case, on witness-provided evidence. Now, we have to get real, Mr. Speaker. We have to get real, Mr. Deputy Speaker. The role of witness, or reliance on witness evidence, is something we've got to look at. We're a small society. Everybody knows just about everybody else. The Honourable Member for Christchurch East is even aware that I have a gun. I wasn't even aware of that. So everybody knows everything about everybody else. And we know what's happening in our society, Mr. Deputy Speaker. And there are some people who are very unwilling to come forward and say anything in the face of certain crimes, or in the face of crimes committed by certain types of perpetrators. And so there is a disinclination to come and say what I saw, to come and say what I know. Because if I speak against him, if I speak against her, if I go to court and talk in this frame, they know me, they know my family, they know my children, they know where I live, they know where I hang out. And so there's a jeopardy, there's an exposure. We must get beyond that point where we have to exercise a measure of reliance, which we now do, on witness evidence only. Hence my questions, where are we with respect to the use platforms and the legislative frameworks relative to DNA and forensics and all that? I don't know. You guys need to tell me and to tell the rest of Barbados. But I think that these things are very important. The immediacy of the threat to witnesses, the capacity to bribe on the part of criminals and offenders, the vulnerability to bribery in the light of poor financial, economic situations affecting many people, very vulnerable to being bribed. All these things are realities that we have to deal with, Mr. Chairman. And we don't have, as far as I know, a situation which allows easily for witness protection. We don't have that facility. I mean, even in Trinidad, they do that, but Trinidad is not much bigger. Barbados, Jamaica, United States. But we need to be able to get beyond the degree of reliance which we now seem to have on witness evidence. and employ some of the more scientific techniques in resolving crimes and responding to the criminal element. I have to ask the Honourable member for Christchurch East to clarify or expand on something for me. I'm referring to section 39, the mitigating factors in relation to the Penal System Reform Act. At 39, he quoted these, Mr. Deputy Speaker. The mitigating factors include the age of the offender. I don't have a problem with that. But the particular circumstances of the offender, such as his social and economic circumstances. Taken at face value, I think I understand that. But it would seem to me that that language leaves some leeway. That language leaves some leeway for some discrimination in the application of that particular mitigating consideration. The particular circumstances of the offender, such as his social or economic circumstances.
Point out.
At the request of the Leader of the Opposition. Mr. Speaker, it starts by saying that nothing prevents the court from mitigating the offender's sentence by taking these things into consideration. So the court has the option to consider them or not consider them, or apply them or not apply them, but it needs to be aware of what they are. And it will be a counsel of prudence for the court to actually address its mind to each of these factors and then decide what weight it puts into it. This is standard language for similar clauses, and what it seeks to deal with, I understand where my friend, the Leader of Opposition, is going. I think that the circumstances of social and economic circumstance tend more to the lower end of the scale than to the higher end of the scale. So it will likely not be a situation where you get off because you are wealthy and come from a good home, so to speak, but rather that the court, in looking at your offense, for example, if you stole 2 loaves of bread, the court will be able to look at the fact that you stole the 2 loaves of bread and you had a family at home starving and a child that hadn't eaten. So rather than allowing abuses by those at the upper end of the social platform, it would allow mitigation and some consideration and compassion to be given to those who are otherwise disadvantaged at the lower end. I hope that has clarified that.
Very well. Member for Mike.
Thank you, Mr. Deputy Speaker, for allowing that point of elucidation from the Honourable Member of Christchurch East. And I understand what he's saying, and that is how I interpret and take this at face value. All I'm saying is there are some persons who, reading this, will alternatively interpret that to suggest that it speaks to privilege, perhaps, for fellows who are better off. We have had a recent instance in Barbados where we began to hear the howls of despair, the voices of recrimination, when it seemed as though there's a law, one for the Medes and another for the Persons, one for the Jews and one for the Gentiles. And all I'm saying is, this language here, falling on the wrong ears, may be interpreted to mean not what the Honourable Member for Christchurch just said, that the court now has to consider this as a mitigating factor, especially with reference to those who are at the lower end, but that the court can now, based on this, look at those who are on the... You agree with that, don't you, Mr. Deputy Speaker?
I'm agreeing with what you're saying.
You agree, Mr. Deputy Speaker?
I'm listening.
Well, I thank you for listening. So, yeah, section 39, and of course, several other guidelines for judicial sentencing on section 41. I'm not going to read them. The honorable member for Christchurch East went through all of them. And I believe that it constitutes a good, what do you call it, paragraph, a good section on guidelines to the court in terms of how officers of the court should conduct themselves with respect to sentencing. But Mr. Deputy Speaker, we need to strengthen our justice systems, as I've been trying to indicate. We need to ensure better victim support in Barbados. We need to ensure better victim support in Barbados. In 2018, yes, we must be concerned that there are adequate sanctions for offenses. In 2018, we must be concerned that we can provide for proper conditions in our penal institutions. All of this is good. But in 2018, we have to up the thing. That's what the people say. We have to up the thing when it comes to this matter of support for victims. And that's a serious responsibility of communities. It's a serious responsibility of the state. Because oftentimes the victims of offenses in Barbados benefit not at all in any way, significantly or in any way sometimes, except to see that justice has been served and somebody is being sent to prison for committing an offense against my person. But I believe we need to better facilitate victim support in Barbados. There are a lot of non-governmental organizations. There are a lot of registered charitable organizations in Barbados, the church not excluded, which are involved in support for victims, not only of poverty, but victims of crime. And the state has to facilitate that kind of work. We've got to make sure in Barbados that there is not only punishment for the offender, but that there's healing, there's remedy beyond what you get at the court for persons who are the victims of crime as well. And that is healing for communities as well. Communities suffer when some individuals suffer, depending on that degree of suffering and the nature of that suffering and offense. So we need to better ensure victim support. We need to better ensure non-discriminatory outcomes for what I call marginalized and minority groups in Barbados. We cannot shut our eyes. We cannot shut our ears. We cannot turn our minds away from the fact that there's a strong view in Barbados that depending on where you come from, depending on how you are profiled by Barbadian society, your exposure to the strictures of the court differ from those of people who are otherwise profiled. That is a reality. And I think a government worth its salt will face up to that squarely and try to address the matter of, even if it is only a perception, non-discriminatory outcomes at court, at the hands of justice, the justice system, for marginalized minority groups, those who live among the lower socioeconomic ranks in Barbados. We need, come back after lunch. I have to go bury the dead, you know, Mr. Speaker, Mr. Deputy Speaker. But if you give me two more minutes, Mr. Deputy Speaker, I will conclude this. Thank you very much. So we have to go there. It's not just about locking away people. It's not just about protecting the rights of people who commit murder and ensuring that there are options of sentencing, but it's to treat the victims, it's to treat to the system. Make sure the system is more expeditious in how it does its work, and make sure that there's a better provision, a better atmosphere, a better environment, a better deal for those who are victims of these various offenses. Mr. Speaker, we need to address factors of urban poverty. This administration historically has been noted, and in its last iteration was particularly reputed for taking a significant interest in the matter of urban poverty and addressing this urban poverty. And I'm saying this because social erosion, community scarring, urban poverty, high not only employment but levels of underemployment conduce significantly to crime in Barbados. And if you are going to address matters such as this, which require change in constitution, a change in so much of the rest of the legislative framework and architecture, if you're going to do this, you can't lose sight of these other things. And all I'm saying is, if you're going to address crime, you have to deal with urban poverty, community scarring, community erosion, high levels of underemployment in Barbados. Member for Christ for St. Michael East will tell you this in glowing terms, far better, using far better language than I can, that you got to address this. Because as long as you have this, you will have a problem of crime. We're preparing now to go into a harsh period of economic strictures. And Lord knows what that will bring in terms of its impact upon those who are already poor. And I'm not treating to that right now. All I'm saying is, if we address the justice system at this level, if we address matters of sentencing, the issue of capital punishment, and we change all of this thing, this is fine, but treat the victims as well. Facilitate groups that are involved in victim support, but also deal with issues that conduce to crime, like poverty, urban community scarring and erosion, and the like, and high levels of underemployment, which is really, really, really a serious feature in Barbados. I thank you, Mr. Deputy.
Mr. Deputy Speaker, I beg to move that this sitting be suspended for lunch until 1:45 p.m.
Question is that this session be suspended until 1:45 this afternoon. All in favor say aye. Those against say no. The ayes have it. This House is now suspended until 1:45 in the afternoon.